Good afternoon. I'm Dan DeRose with 19 News. Coming to you from our digital desk, we're going to take you live into a court proceeding. It's actually a sentencing for a case we've been paying attention to. It was April of this year that a man, Jared Colon, they needed a SWAT team to get him out of his home in Westlake. He had been accused and has now pleaded guilty to brutally beating his girlfriend at the time, nearly to death, in the middle of the street. He had been at a bar earlier that night, and she had to be taken to UH St. John Medical Center. Again, she had life-threatening injuries. Let's take you live now to the sentencing as he has pleaded guilty to felony assault.
I have that pre-sentence investigation. I've had an opportunity to review the investigation, and it has been provided to the parties. On behalf of the state of Ohio, did you receive the pre-sentence investigation, and did you review it, and was it accurate to the best of your knowledge, Mr. Meredith?
Yes, Your Honor.
All right, Ms. Downs?
Thank you, Your Honor. I did receive a copy of the report. I do believe that it's accurate, aside from some additional details that I would add regarding the factual summary of the offense.
All right. Also, in anticipation of the sentencing, the state of Ohio filed a sentencing memorandum. I've had an opportunity to review that. I was also provided a monthly report from Stella Maris regarding the defendant's participation in their program there. And I received from Ms. Downs a copy of a letter that was sent to the prosecutor from the defendant, as well as a letter that he wrote to me. I've had an opportunity to review both of those letters in preparation for the hearing today. I am prepared to go forward with sentencing on behalf of the state of Ohio. Mr. Meredith, first of all, let me ask you this. Are you in compliance with Marcy's law?
Yes, Judge Gallagher, the state is in compliance with Marcy's law.
Is the victim present?
The victim is not present, Your Honor.
All right. You can go ahead.
Thank you, Judge Gallagher. In this particular case, this incident happened back in April. Police were dispatched in Westlake to report of a woman who was lying down in the middle of a street. This was at around 2 o'clock in the morning. Police responded, and there was a good Samaritan there who was helping the victim up. She was laying on the ground. Police tried to interact with the victim, and she was visibly very badly injured. She could very unclearly speak with police. She couldn't really say her name. She couldn't really provide anything as to her birthday or social security, initially her social security number. Eventually, police were able to identify the victim as Miss Ashley Yinger, and then the police were able to connect the dots as to her relationship with the defendant. The victim and the defendant were in a relationship with one another, and then the police, upon further investigation, found a video of the victim and the defendant leaving a bar earlier that night. The two appeared to be intoxicated, and then police went to the home of the defendant, interviewed him regarding this incident, and the defendant admitted to attacking the victim. The defendant admitted to leaving the victim, and the defendant admitted to hitting the victim while she was down. Your Honor, the victim was taken after this to the hospital and was placed in a medically induced coma. Speaking about the injuries is one thing, but seeing them is another. If I may approach, Your Honor, with photos of the victim injuries.
Sure.
Your Honor, the first image is while she was in the hospital after the incident.
Can I click through these?
I have one other image, Your Honor.
That was the same night of the incident?
Yes, Your Honor. And this was 2 days after the incident.
Okay, thank you.
Your Honor, the victim has been cooperative with the state of Ohio, but understandably, she wants to move on from this. This was extremely traumatic, and given what you just saw in these images and the defendant's behavior, the state is asking for more than the minimum. I know there is a presumption of prison. I think not only does this meet that presumption, this should go beyond the minimum, given how severely injured the victim was.
Okay, thank you. Ms. Downs?
Thank you, Your Honor. On behalf of Mr. Cologne, to say at the outset that I don't mean for any of my comments to minimize what happened here, but I do think that there is a big distinction between what was initially reported by the police and the media about what happened here, and the follow-up and the medical records, most importantly, that I think give us a better understanding of exactly what happened. When they were out this day, they had been drinking all day long. At some point, there was another friend of theirs that was with them. That friend was able to take video of some of these encounters throughout the evening, as well as some of the surveillance that was recovered by the Westlake Police Department. And in all of the videos, what is seen is essentially drunken stumbling that's going on. I'm using summaries of body cameras from the detectives' reports, not my own. At 39 hours, they see the two suspects in the parking lot together. They're stumbling, they're attempting to hold each other up while they're walking.
When you say two suspects, who?
Sorry, I did say two suspects, two subjects. Mr. Cologne as well as the victim.
Okay, all right.
They're stumbling, they're attempting to hold each other up while walking. At 41 hours, stumbling in the area, Yinger on her own falls to the ground and lays motionless for several seconds. Cologne stands up over her, swaying due to his level of intoxication. He eventually sits Yinger up, and the two appear to be having a conversation before Yinger again falls back onto the ground on her own. At 43 hours, Cologne is seen pulling Yinger by the arms and trying to get her back on her feet. In another attempt to get Yinger off the ground, Cologne loses balance and falls over her onto the ground. At 44 hours, he gets up, wraps his arms around Yinger's chest area, and they do describe it as him violently trying to pull her up several times before he ultimately gets her to a standing position. The two cross the street, they end up on the tree lawn directly across from the time warp, which I believe is the intersection where she is ultimately found. Again, to full disclosure, they do describe...
So I'm confused. Those incidents that you just described happened on the body cameras of the officers?
Surveillance camera, Your Honor.
All right.
Then they do say Cologne appears to throw Yinger to the ground, but again, and I will get to the levels of intoxication in a moment, but I don't know if this is throwing people to the ground or people, again, stumbling over each other in the state that they were in. I'll fast forward a little bit, but at 49 hours, Mr. Cologne reappears in the camera view and stumbles back in the direction of Yinger. At 51 hours, cameras show Cologne again picking Yinger up and walking westbound out of the camera view. I think that all of those things are important to highlight because they are the video evidence of what we have that evening. I would also like to make it very clear that I'm not suggesting in any of this that Mr. Cologne was being a good Samaritan in trying to help Ms. Yinger up in the state that she was in, but I think that there was a lot more to than what's written in this pre-sentence report as a summary of what happened. Importantly, after they speak with Mr. Cologne was still intoxicated at the time he gave this interview. He does admit that at some point he must have gotten frustrated with her and admits to hitting her and kicking her. He's taken responsibility for that through this plea. But I think that the extent of these injuries are explained by other things. And a very important witness to this is their friend, who I had already mentioned, had been taking video clips throughout the evening of this drunken journey that they were all on together. Mr. Cologne told them about the other friend that was there. They went and interviewed the other friend that was there. The other friend that was there provided the video of some of the events of that evening. According to Polk, Yinger exited the vehicle, began stumbling into the parking lot. While going towards the front entrance of the time warp, she fell and hit her head on the brick wall. The fall caused a laceration to Yinger's forehead, which is what we see in the pictures, and began to bleed. Polk said he was able to clean Yinger's laceration up as Cologne began walking away. But importantly, he provided cell phone video of her hitting her head on a brick wall, falling to the ground, bleeding from the head because of the fall, and Cologne trying to help her up. Again, Mr. Cologne very early the next day, was questioned and did admit that he probably did lose his cool and hit her at some point. But I do think that he was providing fuzzy details of a highly intoxicated night. And the evidence for the intoxication is in the medical records provided by the state. Initially, it is described, and it is in the pre-sentence report, that she has a suspected depressed skull fracture, that she has to be intubated and put into a medically induced coma. The initial medical records are that she was disoriented, that she was prescribed Narcan, that she was tested and tested presumptive positive for both fentanyl and cocaine, and importantly, her blood alcohol content at that moment was 0.455, not 0.0455, 0.455. I pulled up a chart of different levels of intoxication. At 0.02, light to moderate drinkers begin to feel some effects. We all know that at 0.08, the law determines you are no longer legally able to operate a motor vehicle. At 0.12, vomiting starts. At 0.2, most people experience blackouts. At 0.4, most people lose consciousness and some die. At 0.45, breathing stops. This is a fatal dose for most people. 0.455 is not on the charts. It is important to note that at 0.45, breathing stops. That is the medically given reason for her being intubated and placed into that medically induced coma, was because of the severe level of intoxication as well as a suspected head injury. They did numerous tests on her while she was in the ICU. Again, she was promptly intubated to protect her airway. Other precautions were taken in case of major head trauma, of which there ultimately wasn't any. CT scans were done, noting no traumatic injury. There was no skull fracture. There was no brain bleed. She was diagnosed with a hematoma. She had multiple abrasions on her body, but again, I think that comes from this drunken stumbling and by Mr. Cologne's own admission trying to drag her throughout different points of this episode. Medical records indicate that the trauma workup was negative for injuries to not only the head, but also the spine, the chest, the abdomen, and the pelvis. The large laceration at the upper eyelid and bilateral, I can't pronounce it, but on her forehead is the only injury that required medical attention in the way of stitches, and it is the injury which we see documented on the video when she fell and she hit her own head. I know photos were provided. I've seen some of those photos as well. The victim is seen later in this to have swollen and black eyes. The black eyes is from pulling from a head injury and trauma, not from punches to the face.
Is that what the medical record says?
Yes, Your Honor, and I printed out some of the medical records here. I went through them in laborious detail. I have the ones documenting both her blood alcohol level as well as the reason for the intubation. Your Honor, I did not print out the reference to this, but I can tell you that I specifically Googled this condition for the common phrase of raccoon eyes because the swelling did come from pooling from a head injury, which again, I would say could have been her own falling on the brick wall, or again, there is one hematoma that is also noted within this. So all of that to say that I do think that those things are important, and I am not trying to shift blame here. Mr. Colon took responsibility because he did admit to the police that sometime after all of this nonsense that went on, he did get frustrated and he did ultimately hit her. He also made a really, really big mistake when he left her. I don't think that there's any evidence that he left her in the middle of the road. Potentially she had stumbled into the middle of the road after this. But he knows what he did. He knows what he did in the state that she was in. But I do think that the significant trauma that's all noted here is mainly due to two issues, and that is a BAC of 0.455, as well as the evidence that we have that this victim did hit her own head, causing a traumatic injury to her forehead that required the stitches. With regard to the sentencing factors and what makes Mr. Colon's behavior more serious, we would concede that some of those do apply here. That the injury is exacerbated by a physical condition. Ms. Dinger was obviously in a very fragile and vulnerable state before whatever ensued that he is taking responsibility for here. And importantly, he did leave her in that vulnerable position. With regard to serious physical harm, I think I have outlined the fact that the intubation that happened as well as the stitches do seem to be two injuries that were at least exacerbated by the victim here. None of the other factors that would make his conduct more serious apply. With regard to making his conduct less serious, we do have to consider whether or not the victim induced or facilitated the offenses. Again, I think that this is a nuanced argument. I don't want to at all suggest that she provoked or induced an assault, but the mutual intoxication of both of the parties here, I think, obviously led to this. I don't think that, but for each of their own voluntary intoxication, anyone would be here today. With regard to substantial grounds existing to mitigate his conduct, I would like to talk about mitigation more fully in a moment. But with regard to whether or not recidivism is more or less likely, you have an individual in front of you now who is 22 years old. His only prior record is a 2024 menacing case in Rocky River Court. So he doesn't have a long or lengthy record of prior convictions, although we would also admit that this offense did happen while he was still under supervision there. An important one here, drug or alcohol-related activity that he doesn't admit to or that he doesn't want treatment for. On the contrary, I'm going to have a lot to say about all he has done to take care of his significant problem with alcohol use. With regard to remorse, I think that he can speak for that himself, but I would suggest that all of the steps he's taken since this incident show a person that is remorseful and is taking accountability for their actions. And also importantly, the last factor, I think that if Mr. Colon is able to maintain his sobriety, then I would suggest that this offense took place under circumstances that aren't likely to happen again in the future. With regard to his record of treatment, I know the court is familiar with some of this already. We did have a prior hearing in this courtroom with Mr. Colon in regard to his submitting urinalysis samples for the probation department that he was having some difficulty with. At that time, the court was provided with his record of urinalysis samples from Stella Maris that I think happened on more than just a weekly basis. And every single test he has taken since being in that facility since July has been negative for all illicit substances. Importantly, today, this very day, he is celebrating now 4 months of sobriety. As he wrote in his letter to the court, he's working on his 4th step. He, in the last month alone, attended 40 meetings as well as individual counseling. During the time he's been at Stella Maris, he completed inpatient treatment, PHP, partial hospitalization program. He's currently in IOP. His IOP has been extended, not because he isn't working the program, but because they think he still needs some time to reinforce some of those steps. But he is due to graduate IOP on November 12th. He's also in their sober living program. And importantly, I think he's made his own support system. He does have a sponsor, but he also comes to every court date with people from Stella Maris that are, I've witnessed, very supportive in his journey, very supportive in helping him work through the steps of trying to resolve this case. And I think that support system is particularly important for Mr. Colon. While he does have some family involved in his life, including his grandmother, I don't think he has the traditional kind of family support that most people in this room would agree, helps a person become a thriving member of society. His mother was an addict. I believe his father was in prison. He had a traumatic childhood. In taking these steps towards sobriety, he's now also working on his mental health. He was referred to Recovery Resources, I believe. Is that right for your mental health? Signature Health, to take care of mental health issues as well. He was recently diagnosed with anxiety, depression, and PTSD, and he's also getting services for all that now. Initially, when he was brought into Stella Maris, obviously the focus is just sobriety, and so he wasn't kind of getting the other pieces into place, but now that he's more comfortable on that journey, he's also signed up to take classes for his GED. He's interested in looking into programs to try and get into the trades. And what I can say for Mr. Colon is I think that over these last 4 months that he's been at Stella Maris, he's accomplished more for himself and without a court order than most people do while they're on probation. So again, I do understand the serious impact of this case, but I do think that when we're weighing the sentencing factors and most importantly, the fact that Mr. Colon has already showed you that he can be a success on community control, we would implore the court to consider a sentence of community control for him. I think that the state's concern of having the factor of punishment and protection of the community is solved by the fact that if he ever slips up on this sobriety journey that he's on, where he really has turned his life around, there is still a very significant sentence hanging over his head.
All right.
Thank you.
All right, Mr. Meredith, what of what Ms. Downs just said do you take issue with? Did you see the video of her falling and hitting her head and blood coming out of her head?
Your Honor, no, I did not see that video.
Why didn't you share that with him?
It's everything that I read, Your Honor, is from their police report.
Okay.
Verbatim, that's why I read it.
Your Honor, I am aware of the video of them walking out of the bar together, and that's how police were able to determine that the defendant was with the victim before the incident had occurred.
Were you aware that she had a blood alcohol level of .455?
Yes, Your Honor. The state was aware that both individuals were
And
intoxicated.
were you aware that the medical records indicated that they had to do the medically induced coma because of that?
Yes, Your Honor.
And were you aware of this Mr. Polk, who seemed to have some interaction with the two of them?
Yes, Your Honor.
Gave her some kind of medical aid after she hit her head on the wall?
Your Honor, yes. The victim's family indicated that this Polk individual was a known drug dealer.
Well, I didn't ask you that.
Yes.
I asked you, were you aware that he provided medical assistance to her after she fell and hit her head on the brick wall?
Your Honor, not that fact in particular. The state was aware of the fact that she was found in the street. We were not speaking with Mr. Polk.
What is your interpretation of what you saw in the video?
Them walking out of the bar together.
So there's actually no video of him, besides his own statement, there is no video of him assaulting her. Is that correct?
Correct, Your Honor.
All right. Okay. Mr. Cologne? What would you like to say?
Well, first of all, I'd like to apologize for my actions. That's what I'd like to start off with. Second, this really affected me heavy. Like, I lost everything from it. I lost my job, my house, my girlfriend. I lost everything. And all because I thought drinking was helping me the whole time. And it really wasn't. It was just causing the majority of my problems. And I just came to terms and realized that was the main problem for me, was drinking. I had a drinking problem, and it wasn't really helping me. So it's time for me to grow up. That's how I see it. It's time for me to grow up, and it just affected me heavy.
What do you remember about the night?
I just remember that we were drinking all day, from like 8 o'clock in the morning to like, I think it was like 10 or something. The last thing I really remember is that me and Tyshawn were talking at the bar, and she got mad, and I don't remember after that because I kept drinking. That was the last thing I really remember. And to be honest, if I do, like, I don't remember, but I wouldn't just leave it there. I really wouldn't do that.
But you did.
I know, but I wasn't in the right mind is what I'm saying. Sober. If I was, I wouldn't do it. That's not me. I can't live like that no more. I don't want to live like that no more is what I'm saying. I'm actually happy that I'm sober. Like, it feels good to be sober. And it took this, it's sad that it took this, but it really did affect me.
Okay. All right, you can be seated. Okay, so the overriding purposes and principles of sentencing under 292911A are to punish the offender and protect the public from future crime by the offender and others. Protect the public from future crime by the offender and others contemplates the recidivism factors that Ms. Downs was speaking about, and I'll go over those in a minute. To punish the offender and to punish the offender for what he did is the other consideration the court has to weigh. So the law provides some guidance on whether or not Mr. Cologne's conduct was more serious and whether it was less serious. Under the more serious factors, of course, the injury in this case was exacerbated by the victim's mental and physical condition, that being under the influence of alcohol, fentanyl, cocaine, and alcohol at such a high level. I do find that the victim suffered serious physical harm. However, it's really hard to tell from the facts and circumstances and the lack of video and the lack of either the defendant or the victim being able to tell us exactly what happened due to their state of inebriation. It's hard to know what happened.
Judge Gallagher,
Yeah.
could I interrupt you for one moment?
Sure.
I did find one note in the police report as the video after she made the initial fall. The police did note that it should be noted, quote, "It should be noted the injuries sustained during the fall were minor in comparison to the end result after the felonious assault, end quote. This is related to seeing her stumble into the wall with Polk and the defendant present. I just wanted to state that for the record because I didn't see that line. Thank you.
All right, thank you.
Judge, I think I already did address that during my mitigation, but again, the detective can say that all he wants. That was the only injury that was treated at the hospital.
What injury?
The injury to her forehead from falling on the brick wall, where she required 5 stitches.
All right,
I went through all 474 pages of the medical records.
all right. So, the remaining factors under whether Mr. Cologne's conduct was more serious don't apply. 7 of those factors don't apply. Whether the conduct is less serious, looking at whether the victim induced or facilitated the offense, I don't think she did. If we're looking at what he did versus what was happening to her because she couldn't stand upright, I don't think she induced the falls to the ground. I mean, she was intoxicated. She was unable to stand. She was unable to walk. But as far as him losing his temper, she did not induce or facilitate that. I don't think that Mr. Cologne acted under strong provocation. And I don't think there are substantial grounds to mitigate his conduct at the time. Whether recidivism is more likely, most of those factors don't apply. So when the law tells us to see whether to protect the public from future offenses by this offender, those recidivism factors don't apply. He has 1 prior misdemeanor to which he was on probation from 24. So, 24?
Yes, Your Honor.
But other than that, he has no record at all. So he has a misdemeanor record. He was on probation. I would say that doesn't constitute a history of criminal convictions, and he has no juvenile record. He did not respond favorably to sanctions because he picked up this new case. He does show a pattern of alcohol or drug use related to the offense, but he has not refused to acknowledge it or seek treatment. So that's kind of a toss-up. I do think that he shows genuine remorse. Whether recidivism is less likely, meaning will he harm or commit new offenses, he did not have a prior juvenile delinquency adjudication. He's only 22, so that's significant. He has a prior adult conviction for the misdemeanor. The presumption is prison. You know, it's really hard for me to kind of understand what happened in this and what he is legitimately responsible for as far as her injuries versus what actually happened because of her level of intoxication. Based on the medical records and based on the police reports that you read from, the body cam that you read from, it makes it, you know, what seems to be a pretty simple, easy case to look at and know what a sentence should be becomes very much, it's much murkier based on listening to those, to that situation. So here's what I'm going to do. You're going to serve some jail time because you did assault her. By your own admission, you assaulted her. But you're going to serve some jail time, and then you're going to be on probation. So part of your probation is that I do find that the presumption is overcome by the work that he has done since the incident, and the presumption is overcome because it's very unclear to me how those injuries were sustained. Based on the medical records, based on the police reports, there's no doubt she sustained serious injuries. or at least by looking at the pictures. But the medical records don't support that it was due to an assault. So, you know, that makes it hard to punish somebody at the level of a felonious assault for those injuries. So, but you are going to serve jail time because you have no right to put your hands on anybody ever. Your hands, your feet, whatever happened. That's unacceptable behavior, whether you're sober, whether you're drunk. It doesn't matter to me. So you are going to spend some jail time, 60 days in the county jail. Then you're going to be on probation for 2 years. In the domestic violence unit. Your fines, fees, and costs are waived. Once you're done in serving your 60-day sanction, you're going to go back to Stella Maris, and you're going to finish the IOP that you're doing, and then you're going to go to sober living, and you're going to live in sober living, and you're going to be regularly drug tested. First positive, you'll be arrested. Any violation of your probation, you're looking at 8 years in prison and 18 months to 3 years of post-release control. So he's ordered remanded and remanded to the county jail.
Dan DeRose with 19 News here as we watch Jahard Colon being taken into custody. You heard the judge explain this was a very difficult situation, and as was spelled out here, the injuries to the young woman involved here, his girlfriend at the time, yes, were severe, but the defense did a very good job of saying, look, Your Honor, there's video of her, both of them, after they had been drinking for 8+ hours. She was stumbling and staggering out of that bar as he was. He kept trying to get her to stand up. Apparently at some point she fell and hit her head on a brick wall. That may have been the cause of at least the blood injury that then gave her the black eyes. I think his defense did an incredible job saying there's nothing in the medical report that said her injuries being intubated because of her blood alcohol level, 0.455. That is astronomical. As you heard his attorney say in court, if you go through the levels of intoxication, most people would be dead at that point. She also had fentanyl and cocaine in her system, which is one of the reasons the defense feels the medical staff had to intubate her because of how the pure chemicals and alcohol in her system. The state was asking for prison time. Instead, the judge, she did say, look, you are never to put your hands on anyone. He did admit to detectives that although he doesn't remember, he thinks he got frustrated with her, punched her and kicked her. And so that's what the judge based her decision on, to give him 60 days in county jail instead of sending him to prison. I don't think anybody likes the idea of being locked up, but I'll venture a guess that being locked up in county is a heck of a lot better than being sent down to prison in Maryville or anywhere else. We're going to wrap this up. We'll have a complete story on this when we start 3.5 hours of news and First Alert weather on Channel 19 at 3 o'clock. Until then, I'm Dan DeRose with 19 News. Have a good afternoon.